Subro Scoop. We're excited to welcome you back to another episode of our webinar series featuring attorneys and shareholders from Wellman. In today's session, we'll explore the many facets of selecting, retaining, effectively utilizing an expert in the subrogation industry. Before we dive in, I'd like to take a moment to introduce ourselves. I'm Tiffani Palmer, a shareholder in the Michigan office, and joining me today is Michael Chapman.
Hi, everybody. I've spent most of my career defending insureds in commercial litigation involving really anything that crashes, catches on fire, explodes, blows up, or malfunctions. A little bit of subrogation, and recently in the last 5 years, entirely subrogation.
Okay, thanks, Mike. And we look forward to sharing our discussion with you today. Before we officially get started, I want to go over a few housekeeping items. As a reminder, this is an interactive session, so please submit your questions using the question feature located at the webinar control panel. We will address questions throughout the presentation if there's time. If there's not time, then we will follow up with those answers. Please note that today's webinar is being recorded. Following the presentation, all of you will receive a link to the recording along with a copy of the presentation materials. If for whatever reason we do not make it through the entire presentation, rest assured you'll be able to review the end of it with the PowerPoint once you receive that. At the conclusion of the webinar, you'll also receive a brief survey which will appear on your screen. We truly value your feedback, and we appreciate if you can take the moment to share your thoughts regarding today's session and future webinars. That helps us to determine the content that we'll utilize for these presentations. So thank you again for joining us, and let's go ahead and get started. So we have our first poll question. So I want to ask you all, how often do you utilize experts in handling subrogation claims? And so you can put your answers in the chat box if you don't have a prompt on your screen, and I'll repeat the question for you. So how often do you utilize experts in handling your subrogation claims? So A will be rarely, only for catastrophic or highly complex losses. B would be occasionally, dependent on liability disputes and the damages. C, frequently. Experts are a regular part of my claim strategy. Or D, almost always. I involve experts early in most claims. Okay, and I have a few interesting answers that are popping up. Occasionally, okay, yeah. Good, good. Thanks so much for sharing those, and continue to pop those up. We review them and we take that information, and we'll actually have another question for you later on. So we'll go ahead and continue as you all populate those answers in if you have one. By the end of today's presentation, our goal is for you all to walk away with a practical understanding of how experts can directly impact the success of your subrogation claim. We'll begin by discussing the critical role experts play in subrogation matters, not only in improving liability and causation, but also in strengthening negotiation leverage and litigation strategy. We'll also focus on one of the most important questions adjusters and recovery professionals face. When is an expert truly necessary? And when might that cost outweigh the benefit? Not every file requires an expert. So for that person who may have put that as a poll question, we're not saying you're wrong, but we hope that you have a different outlook at the end of this presentation. But it does require strategic decision-making in determining when to get an expert. Throughout the presentation, we'll identify different types of experts commonly used in claims. We'll also discuss the financial benefits experts can provide. In addition, we'll touch on the legal standards surrounding expert testimony, including how experts are qualified under Daubert and why reliability matters in today's litigation environment. Timing is another major theme of today's discussion. Retaining the right expert at the right stage of the claim can significantly affect the outcome of a case. So we'll review best practices for early evaluation and retention of decisions. And finally, we'll cover some of the most common expert-related mistakes we see in the subrogation claims field, along with practical ways to avoid them. Our hope is that today's session provides both practical guidance and strategic insight that you can immediately apply to your own files and recovery efforts. So I'll turn it over to Mike.
So when we get a file, we always think about what are we going to do to prove our case in court. And when we go to court, there are exactly two types of witnesses, and only two. There are lay witnesses who can testify based on what they saw, personal knowledge, and everybody else is an expert. So we typically think of an expert as the expensive engineer when we mention the word expert, but really an expert witness is anybody who may not have personal knowledge, but can testify based on special skill, education, training, or experience. So frequently what we see in auto cases, for example, it looks like a word versus word accident. You know, you've got two drivers hit each other and he said, she said. So the carrier may be looking at the police report saying, well, the police officer said it's their fault. It's not our fault. But the question we have is, well, how are we going to prove that in court? Who's going to say that? So frequently, you know, we may need an expert. Most carriers will assign an adjuster to come in to testify based on, to authenticate records. You know, the business records say that we paid $10,000 in this accident. Well, good defense counsel is going to say, sure, we agree that you paid $10,000, but how do we know that's reasonable? It's just a little minor accident. And then that's when maybe the adjuster needs to become an expert. Well, based on skill, education, training, and experience, you know, a property adjuster can look at a car and say, well, obviously we need to replace this, 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 and this, and this, and it's going to cost about $10,000. So just remember, anytime that you're talking about an accident or an event or anything, you've got people that saw the event and can testify based on personal knowledge, and everybody else is going to have to be an expert. All right. So why do experts matter? Besides the lay witnesses who can tell us sort of what they saw, the primary reason we hire experts or need experts is to establish causation. Causation is the number one essential element in every negligence claim. You've got to establish a duty, a breach of the duty, causation, and damages. And frequently we need experts to establish liability, causation, and sometimes damages. Experts are also really helpful because they go in, they're really good at preserving evidence, they can help your argument, they eliminate alternative causes, get rid of defenses. And if you have a good expert or somebody that you can rely on to go in and convince the judge and the jury that our side is right, it carries a lot of weight. You know, just kind of keep in mind that attorneys are, I look at attorneys as sort of ringleaders in trial, where we sort of direct traffic and guide people around. But whatever we say, it doesn't carry the day. We really need to rely on our witnesses, and those are lay witnesses and expert witnesses. So that leads us into sort of what is an expert. Obviously, if there's a complex case, you're going to need an expert. You've got, if it's an engineering or a structural failure, if it's a financial accounting issue, if it's a medical malpractice issue, anytime there's an explosion or a fire or a product malfunction, you're probably going to need an expert. But I think the point that I would like to make is that experts are also needed in every other case, potentially, and that's where it gets really tricky. You know, so sometimes we have situations where, you know, the generator caught on fire. Well, obviously everybody knows the generator caught on fire, but who's going to say what caused the fire? And good defense counsel are always looking at other alternatives that may have caused the fire. How do we know it wasn't an electrical surge? How do we know it wasn't lightning? How do we know it wasn't dirt or debris or malfunction? Or how do we know it wasn't user error? Or how do we know it wasn't misuse of a product? Well, a good expert is not only going to rule out alternatives, they're going to really focus down and pinpoint the actual cause of the accident. So frequently in complex cases, you're going to need an expert, and frequently in other cases, you may need to consider an expert.
So I agree, Mike, and I want to piggyback on that. One of the biggest misconceptions in subrogation is that experts are only necessary for trial. In reality, the right expert can increase recovery potential long before litigation even begins. So, from a liability standpoint, experts help solidify causation and provide technical support that strengthens the overall claim. Whether you're dealing with, as Mike mentioned, a fire loss, product failure, equipment malfunction, or a complex vehicle accident, experts often provide the foundation needed to move a claim from suspicion to provable liability. Most importantly, experts help translate technical failures into understandable conclusions that carriers, counsels, and really the jury, which is the most important thing, can follow. Experts also create leverage during negotiation. Defense carriers tend to evaluate exposures differently when they know a qualified expert has inspected the loss, documented the findings, and supports the theory of recovery. A well supported expert opinion often changes the conversation from is liability disputed to what is this case worth? Another important point for recovery professionals such as yourself is preservation. Early expert involvement can prevent critical evidence from being lost, altered, or destroyed. From a litigation perspective, experts help position the file for success early. Strong reports, scene documentation, testing, and demonstrative evidence can streamline discovery, strengthen depositions, and improve presentation at trial. At the end of the day, experts are not simply an expense on the item line. When used strategically and at the right time, they become a recovery tool that can strengthen liability, increase your settlement value, which is what is important to us, preserve claims, and improve overall outcomes. So then I want to go to one of the most important decisions in a subrogation file is determining when an expert involvement is necessary. While not every claim requires an expert, there are clear indicators that should trigger that evaluation. Experts are often critical when liability is complex, such as technical failures, and we kind of went over that before, multiple party losses, a product malfunction. They help establish that what failed, why it failed, and who may be responsible. They also become essential when causation is disputed, especially in fire losses. And Mike touched on that as well. Structural collapses, water intrusion claims, and equipment malfunctions. Those are sure indicators where expert will probably be needed. And then the severity of damages matters as well. In high exposures, early expert involvement can protect and maximize recovery potential. Litigation risk is another major factor. If liability is denied, you have aggressive defense counsel on the other side, or you anticipate there are going to be Daubert challenges. Retaining the right expert early on can significantly strengthen that file. There are also practical warning signs that should prompt immediate consideration of experts, including if the evidence can deteriorate, if there's specialized testing that's needed, when you have code compliance issues, or claims involving manufacturer or technical industry standards. And finally, if the defense has already retained an expert, you may want to consider retaining one yourself because that may help support and remain competitive in your claim. Ultimately, expert retention should be a strategic decision driven by complexity, exposure, preservation concerns, and litigation risks. And just as important as knowing when to retain an expert is knowing when not to retain an expert. In some files, expert involvement simply does not add meaningful value to the expert recovery. For example, from when liability is obvious, such as a clear rear end accident or an admission a fault has been established, or strong video evidence. The facts may already speak for themselves. In those circumstances, spending additional resources on an expert may not be in that claim's best interest. The same analysis applies when the damages are minimal. An expert can be costly. So you want to take a look at your actual damages and how much they're worth in relationship to what the expert can return, bring to the table, and how much they can increase the value of the claim. What is the return on investment for that particular expert? Experts may also be unnecessary when the facts are straightforward and do not require technical explanation. If a judge or jury or opposing carrier can easily understand the liability without any specialized testimony, you may want to think twice about retaining an expert. And finally, when causation is undisputed, the defendant has already accepted responsibility, you would also want to think twice about retaining an expert for that as well. Ultimately, expert involvement should always be, as I said before, strategic, and it should be what's in the best interest of that subrogation claim. The goal is not to use experts on every file. It is to use them when they create leverage, they strengthen recovery, and improve the overall outcome.
It's not easy to determine when or whether you're going to need an expert, and it really boils down to a cost-benefit analysis. So I have a case right now where an insured dump truck backs up onto a dumping pad, a concrete pad, and the dump truck driver was guided into place by what we call a spotter, and the spotter is affiliated with the adverse party. And when the dump truck backed up and started to dump the load, the concrete pad collapsed, it broke, and the dump truck tipped over. And it damaged the dump truck. It's a very expensive claim. So the question is, when we go to trial, we're going to have lay witnesses. Lay witnesses are the people who were there, who saw what happened. And everybody's going to say, well, the concrete pad was structurally insufficient for the weight of the dump truck. But does that mean the bad guys should lose or we're going to win? Maybe we need an expert. So the questions to ask are, are we going to dispute liability? Are we going to need to go to trial? And if so, if you want to win the subrogation case, well, we're probably going to need an expert. But experts are expensive. Is the claim worth it? And that's really only a question that, the insurance companies can answer. And sometimes you got to remember, experts, they don't know everything. I mean, sometimes experts can't figure out what happened. There's nothing worse than, having a complicated auto fire and having the expert go in there and saying, yeah, I can't figure out what happened because there's nothing left. Or a dryer fire where the expert says, yeah, it could have been misused because this thing wasn't cleaned for 5 years. And sometimes, worst case scenario, they're going to tell you, yeah, your insured was at fault. Sometimes they're going to say, the driver of the dump truck's ultimately responsible. And I mean, he put the dump truck in the wrong place. So it really comes down to a cost benefit analysis based on multiple factors. Primarily, what's the claim worth? How much do you want to win? Is the claim disputed? And what do we have to try to give it our best shot and shake the tree and see if any money falls loose? So best practice, though, is if you think you're going to need an expert, you want to get an expert as early as possible. Experts are really good at scene preservation, and they're really good at preventing spoliation of evidence. So, and that's critically important. They'll go in, take pictures, document the scene, gather evidence. And unfortunately, when you're not dealing with the subrogation component, most insurance carriers are primarily concerned with damages. So they'll send somebody in to evaluate damages only, and they're not really thinking about what's the cause and is there any subrogation potential. So the most important thing is if you send in an adjuster, you really want to make sure that you at least take pictures and preserve evidence, even if you don't get an expert. But obviously getting an expert as early as possible is the best practice. So evidence preservation and spoliation is very, very important, because if the evidence goes away, then you decide to hire an expert at a later event. So for example, if the dump truck backs up, the concrete pad breaks, we've got to have some pictures. We've got to have some evidence, because it's going to come down to, was the concrete pad of sufficient thickness, bolstered with rebar? You know, was it 8 to 12 inches? What type of concrete was it? You know, was it based on compacted gravel, or was there erosion going on? And those kind of things, they disappear. And once they vanish, all the evidence is gone and we can't prove our case. So it's incredibly important to document the scene with photographs, measurements, get the expert, maintain the chain of custody, and because if you don't preserve the evidence, the case disappears.
Okay, I agree again with you, Mike. And because experts play such a major role in subrogation, it's important to understand the Daubert standard and how courts evaluate expert testimony. Under Daubert, judges act as gatekeepers. Their role is to determine whether an expert's opinion is reliable, relevant, and based on scientific, valid methods before the testimony is even presented to the trier of fact. It's important to know that judges do not decide whether the expert is ultimately correct. And that's good. We don't want judges making that decision. Instead, the court is evaluating whether the expert used a reliable methodology and whether the opinions are supported by sound principles and proper investigation. For you all, this is why expert selection matters so much. A highly qualified expert with a well-documented methodology can significantly strengthen a case, while a weak or unsupported opinion can create major challenges during litigation. Let's go a little deeper. When courts evaluate expert testimony under the Daubert standard, they are primarily focused on whether the expert's methodology is reliable and admissible. One of the first factors the courts will look at is the testability, meaning whether the expert's theory or methodology can actually be tested and whether it has been tested in practice. Courts also consider peer review in publications. In other words, has the methodology been subjected to scrutiny within the relevant professional or scientific community? Another important factor is error rate. Courts may evaluate whether there is a known or potential rate of error associated with the methodology being used. Judges also look at standards and controls, whether they are recognized procedures or guidelines governing how the methodology should be applied. And finally, courts consider general acceptance. If the methodology is widely accepted within the relevant scientific or technical community, it is more likely to survive a Daubert challenge. That was a mouthful. The key takeaway for subrogation professionals is that admissibility is not automatic. The party offering the expert testimony carries the burden of establishing reliability. That is why it's critical, as I said before, to retain experts who not only have strong credentials, but also follow documented, defensible methodologies. Let's go even further. Historically, Fry focused primarily on whether a scientific opinion was generally accepted within a relevant field. Daubert expanded that analysis by requiring courts to evaluate, again, the reliability, methodology, and scientific validity as well. The key takeaways is that while some state courts still apply Fry, all federal courts follow the Daubert standard. And let's go to a little bit more history. These three cases that are on your screen basically have shaped the modern expert testimony regarding the Ford case law. Daubert, as I said before, establishes the judge as the gatekeeping role. Joyner gave appellate courts authority to review those decisions, and Kumho Tyer expanded Daubert beyond scientific conclusions to include engineers and other technical experts. So now let's take all of this information that we learned from the cases and determine how do we qualify an expert. To qualify an expert, the witness must possess specialized knowledge, skill, experience, training, or education that will assist either the judge or the jury in understanding the evidence or determining facts at issue. An important point for you all to remember is that formal education alone is not required. Courts often recognize the practical experience and specialized training that can be attained without certain academic credentials. And I think Mike gave a perfect example. As a claims professional yourself, you potentially can qualify as an expert and to speak as and testify as an expert on a case. Another example would be a police officer with extensive accident reconstruction training and years of investigative experience. They may also qualify as an expert as well. So it looks like we may have a few questions, but I'm going to go ahead and finish this. And if we don't get to all of the questions, then we will for sure follow up with you all. The key takeaway is that courts focus not only on titles or degrees, but on whether the witness has reliability in their expertise to be able to assist the trier of fact. Now, when evaluating a potential expert, there are several key areas that you all should review. First, their education. That includes degrees, certifications, specialized training, anything that's relevant to the laws. Second, their experience. Courts and juries often place very high weight on the years in the field, prior investigations, and real world industry experience. It is also important to evaluate the expert's testimony background, including prior deposition, trial testimony, and any Daubert challenges or exclusions. What you do not want to happen is your expert to get up there and they look to be like a bought and paid expert, that they only testify in subrogation cases, and they always say that it's somebody else's fault. It's never the insurance fault. So you want to look at their background to make sure that they don't appear to be a bought and paid expert. And finally, their professional reputation. Their professional reputation. There we go. So look at their publications, industry memberships, teaching experience. All of those can strengthen the expert's credibility. Ultimately, the goal is to retain an expert who is not only qualified on paper, because that's a little bit easier to see, but have a conversation with the expert, interview the expert, see how their credibility, experience, and their ability to defend our position at trial will work.
So every expert is going to be challenged. It's what we do at some point or another. What happens is usually you finish paper discovery, you may take some depositions, you may go through a mediation, but at some point prior to trial, there's going to be a motion in limine or a motion to exclude evidence. And typically that is going to be in the form of a Daubert challenge. Due to the high stakes of these challenges, I did notice that the Michigan Bar Journal refers to these motions as Death Star motions because they can define, settle, or terminate litigation. The three ways that we're looking to attack an expert is number one, through the expert's credentials. because it's pretty easy to say that, hey, your fire investigator is not an engineer, and the other side's going to argue vice versa. We also frequently attack the data that was used or ignored, because often medical doctors will render an opinion on causation, but they didn't know about the motor vehicle accident 2 weeks prior. So if they didn't know about it, then that sort of throws their expert opinion out the window. And the final way is we're looking at the reliability of the expert's methodology. And this is the big one. This is the Daubert challenge. And the question really, is it science or is it voodoo? Are you making something up? Did the expert show his work? And this is why in 3rd grade, your math teacher always says, show your work. The outcomes, they're unpredictable. In state court, what I find is that the judges are going to let everything in. They're not so much the gatekeeper as door persons who let things in even when they shouldn't. And in federal court, it's exactly the opposite. They're quick to exclude experts if they don't pass muster. I like filing these motions early. I like filing them often. I believe that I need to educate the courts as to what's coming ultimately at trial. But the trend is we're going to let the expert in. So what do you do, before hiring the expert? What I like to do is I of course ask for their CV or their resume, and I ask for their rate sheet. I want to evaluate how much they're going to cost and do they look like they have the credentials. The number 2 question I always ask is, have you ever done this before? Have you ever been an expert before? If you've never been an expert, that makes me nervous. But if they've been an expert frequently, I feel better. And then I drill down a little bit and say, well, have you ever been an expert on this exact issue? And then have you ever been an expert on both sides of the story? I mean, we don't really want an expert who's, as Tiffani said, unilaterally in favor of the insureds always, because that looks bad. And then you get into the soft skills. You sort of have to evaluate whether the expert's likable, credible, trustworthy. Are they an educator? Can they explain things to the jury? Sometimes you always want to ask if the expert's ever been excluded or the subject of a Daubert motion. What I found is that they frequently have no clue. So sometimes you're going to have to rely on your counsel to do a little background digging, because if they've ever been excluded in your state or in another court, that absolutely is going to be used against you. And sometimes the expert has no clue whether they've been challenged or not. And then it's time for a quick poll. When you have utilized an expert in subrogation claims before, how did that impact the case? Did the expert improve the outcome of the case? Did the expert negatively impact the case? The expert had little to no effect on the case, or the expert impact was unclear?
Looks like improved is the winner.
Yeah, I agree. It definitely gives you settlement leverage and gets you ready in case you have to go to the next step. So here's some red flags. So here's some red flags to look for when you're selecting an expert. And even though you've used an expert before, some people automatically go hire a certain firm or a big expert outfit. They, for whatever reason, they're comfortable with them, or they provide a good value. You really want to make sure that, the expert is using the scientific method. They're using general science that's accepted in the field. They're not using proprietary methods that only they're aware of. You want to make sure that they're not using selective data, cherry picking favorable evidence. They have to really consider everything. Frequently, though, we do see experts render opinions that are sort of vague. They do misapply data. they go too gung-ho on one side or the other. They lack technical support. You know, there's an expert in Cincinnati, for example, and I'm not going to mention his name, but he'll basically say he's an engineer and he'll say whatever you pay him to say. And there are a bunch of those guys out there, but we've had quite a bit of luck getting him excluded from cases over and over again. But for whatever reason, insurance companies keep hiring him. And then this slide continues on the next page. So you are looking for inconsistent opinions. You do want to see what they've testified to before. And I really do like to see if they're good educators. Can they communicate effectively? Have they ever been in the courtroom before? There's nothing worse than having an expert who is really good on paper, but you put them up for a deposition, or her, or you bring him or her into court and they just sit there and they just freeze. They just don't know what to say. And that's a really bad situation to be in. I usually start by asking the expert to tell me their opinion before they put it in writing. That way we're not stuck with it. I like to make sure that the expert has identified both the cause and the origin of the problem before we put anything in writing. And then I like to ask pesky questions. I like to ask the expert, and I would encourage you to do this too. Why are you right and all of these other theories are wrong? When the generator caught on fire, how do we know that the fire wasn't caused by lightning or an electrical surge? How do we know that the fire wasn't caused by debris on the generator that caught on fire? Or how do we know that the generator didn't catch on fire because it was out of oil? Those are perfectly, excuse me, legitimate questions to ask the expert. And then if the expert can explain it to you in a way that you understand, you've got a good expert.
Yes, Mike, before we actually get our expert report in writing, it's good to know what they're going to say in that expert report, because without doing that, you end up with an expert report that could be used against you later. So I often ask many similar questions to you. So for example, one, are you going to be able to testify for me favorably? Can you testify within a reasonable degree of certainty? And actually using those words, you're kind of cross-examining them a bit during your discussions to see how they hold up. And maybe that is not the expert you want to utilize if they don't hold up well. But once we get to the point of an expert report, a strong expert report does more than provide just conclusions. It explains how the expert reached those conclusions in a clear and defensible way. So if it's well prepared, an expert report should outline the scope of the assignment, identify the materials reviewed, and document the inspection details and investigative steps taken. It should also clearly explain the methodology used, the findings made during the investigation, and the opinions being offered. Most importantly, the report should connect the conclusions to supporting facts, testing, photographs, documents, or other evidence. Courts and opposing counsels want to understand not just what the expert believes, but why they believe it. And not just courts and opposing counsels, obviously the fact finder wants to have that information. They want to understand that. From a practical standpoint, the best reports are clear, they're organized, defensible, and easy to understand. Even highly technical issues should be explained in a way that everyone could understand it, from the claims professional to the attorney to the judges and to the jury. So I implore the method of just break it down for me, plain English. And so if you're talking to your expert and they're talking at a high level, because this is their technical field, and sometimes experts have a tendency to do that, make them break it down to a basic level. Because remember, that's who's going to be on your jury, a whole bunch of non-technical experts. So the expert needs to be able to talk clearly and plainly about what their conclusions are and how they got to there. So it's very important that you use your expert report, if it's strong, as a method to improve your settlement leverage, strengthen your legal position, and obviously help withstand challenges to admissibility. That's what it can be used for. So moving on, for the claims professional, one of the most important things you can do is set your expert up for success early in the investigation. You do not want to have an expert that you talk to and they do not have all of the information, and some information potentially could change their opinion about the case. The more complete and organized the information provided to the expert, the more effective and defensible their opinion will be. This includes complete claims files, very important. Photographs, if you have recorded statements, obviously your repair estimates, any preservation documents, prior inspections, access to scene whenever possible. Experts can only work with the information they receive. So gaps in documentation or delays in sharing evidence can create significant challenges later in litigation. Equally important is preserving evidence immediately. Whenever possible, retain physical evidence, take thorough photos of the scene and damaged property, preserve electronic data. That's something that sometimes is forgot about, and maintain a clear chain of custody. Many cases are won or lost during the early investigation stage. Strong documentation and proper evidence preservation not only strengthens the expert's opinion, but also protects the overall recovery opportunity. One of the best ways to improve subrogation outcomes is simply avoiding some of the most common expert-related mistakes. A major issue we see is waiting too long to involve an expert. Delays can lead to loss of evidence, missed inspection opportunities, and weaker opinions. Another common mistake is hiring the wrong specialty. Not every engineer, investigator, or reconstructionist is qualified for every type of loss. The expert's background should match the specific issues in the claim. Then, failing to preserve evidence is another critical problem. Once evidence is altered, destroyed, or poorly documented, recovery opportunities can all but disappear very quickly. Communication also matters. Experts need to complete information timely, updates, and provide timely updates and clear expectations in order to provide strong and defensible opinions. It's important that you should be mindful of Dalbert issues early in the case. And I'm not asking for you to obviously commit that to memory. You would work with your attorney to help you with that. But just keep those things in mind. What methods are they using? Is this reliable? Things like that. A technically weak or unsupported methodology can create major admissibilities later in litigation. And at the same time, experts should be used strategically. Retaining overly expensive experts on low exposure claims may not make business sense and can negatively impact your recovery. And finally, even a highly qualified expert can struggle if they are not properly prepared for deposition or trial testimony. So from a claims professional perspective, you want to make sure obviously your attorney has prepped them for that deposition and that trial. You don't want your expert to be surprised when they're testifying. Ultimately, expert involvement works best when it is proactive, strategic, and well managed from the beginning of the file to the end.
So just to piggyback on what Tiffany said, sometimes you're going to get an expert report on the recovery side that's been put together before your involvement, and you're going to look at it and say, I don't understand what's going on, or this looks a little bit inadequate to me. That happens. That happens frequently on our end. Either get it over to us or send it back to the expert and say, hey, can you give me a supplement? Can you explain? You're missing a little bit here. What happened here? What do we need to do? So it's not too late and it's not set in stone if the expert sends you something that doesn't pass your smell test. So we have a case study. We have a fire loss. The scenario is a homeowner reports a residential fire that caused substantial damage to the laundry room, adjacent kitchen, and second floor smoke damage throughout the home that allegedly originated in the dryer. Are you going to need an expert? And if so, what kind of expert are you going to need, and when do you need to get the expert? So the answer is yes. You know, anytime we have a fire involving a potential appliance malfunction, you're probably going to need an expert. You're going to have to figure out whether it's an electrical problem, or whether it's a house problem, or whether it's the insured user error, or whether it's an appliance malfunction. You know, you're going to have multiple parties possibly involved. You're going to have anybody who's doing work in the area. You're going to have maybe the homeowner people involved. You're going to have the electrical people involved. You're going to have fire people involved, and you may have the appliance people involved. So you have to really be aware that you know, the red flag that goes up is, yes, we're going to need an expert, but maybe, you know, what type of expert may come into play a little bit later. So when we're looking at, you know, sort of what type of expert, usually you're going to have the fire department go out and take a look at it. Sometimes they'll assign a cause and origin investigator, the CFI, to sort of trace back where the fire originated, but they may not be able to come up with the cause. So to figure out the cause, you may need to pivot and go with the electrical side. You may need to go to the mechanical engineering side, and you may ultimately need to preserve and go with the product side, you know, because fires are complicated. You know, we know just based on common experience that all clothes dryers just for whatever reason catch on fire. We know that all bathroom vent fans just, I don't know, they catch on fire. But when you really need to boil down to making the claim, you really got to pinpoint what exactly it is that malfunctioned and what is the cause of the fire, not just the origin. So I think we're on, when should the expert be retained? No, we're one up. So a fire origin and cause investigation, that's usually the first expert, you know, retained. You got to figure out what happened, document the scene, and then usually the electrical or mechanical engineer is going to be step two. They may be the same person, probably not. So normally fire investigators aren't engineers. Sometimes you get lucky and you can piggyback using the same expert who went out to investigate cause and origin, and then turn them into use their mechanical engineering skills to figure out what happened with the product. So when should the expert be retained? In this particular situation, whenever you have sort of a complicated fire and you're looking at, well, what caused the fire? What happened? And if you can pinpoint that we have potentially an appliance fire, you're going to need an expert. You're going to need an expert early, and you know, preservation of the evidence is really critical, because you're going to have to put everybody on notice. You're going to have to make sure everybody gets out to the scene. You're going to have to make sure everybody gets everything inspected. And a lot of insurance companies, at least their primary responsibility is to make sure everything gets cleaned up and put back together and the insured's taken care of. But hiring the right expert early can make sure that everything gets documented and preserved and kept, so that you can avoid the spoliation and maintain the subrogation claim. So now we're at case study number one, fire loss critical point. This is really important. So origin and cause are not the same. Origin is where the fire began. Cause is why the fire occurred. We often see, I mean, frequently see, fire investigators will go out to the scene and they'll drill down on exactly where the fire started. And they're pretty good at pinpointing that. They can look at V burn patterns and trace fire back to, and they're like, here it is. Here's the arcing. Here's the point. Here's where it started. But they're not so good at figuring out what caused the fire. Did the arcing cause the fire? Or did the fire cause the arcing? Fire investigators, they're usually pretty good at figuring out where the fire started, but they're really not very good at figuring out what caused the fire. So even when you have something that seems fairly obvious, like, when you put a stack of pallets outside of a building and they just magically catch on fire, fire investigators really good at figuring out where the fire started, but they're really terrible at figuring out, well, what caused the fire? Was it, was there a bird that flew over and dropped a bomb on the pile of pallets? So you still may need an engineer at some point to sort of figure out how the product malfunctioned, how the electric problem, caused the fire, whether there was a mechanical failure, a structural failure, or some other bizarre voodoo science thing that caused the fire.
Okay, and so now we have case study 2, and we're getting close on time. So this one is going to be very straightforward. Driver A rear-ends driver B at a stoplight during rush hour traffic. The police report notes driver A admits he looked down briefly at his GPS. There's our first indicator. He was unable to stop. It's clear weather, dry roadway, no evidence of mechanical failure, property damages moderate. I assume that you've guessed the answer is we do not need an expert. So as far as the question, is an expert necessary? Would expert cost outweigh the benefit? What evidence should still be preserved? Could this case be resolved without litigation? And we'll go ahead and go to the next slide. Yes, an expert is likely not needed for all of the obvious reasons. Clear liability, causation is clear. There's nothing complex. And we may be able to use just lay witnesses, just the drivers that were involved, the photographs, depending on your jurisdiction, whether a police report can be admissible or not. But you still could use the police officer to testify to the scene itself, the repair estimate, things like that. And if you're looking at it from a cost benefit analysis, we said there was moderate damages. The expert is really not going to bring anything meaningful to the case that's going to increase your dollar amount. So that may not warrant retaining an expensive expert for that. But if you have some other issues like the liability potentially becomes disputed, potentially you may want to look at an expert. You still have moderate damages. If then we have serious injuries, so someone loses a limb, something along those lines, there's some sort of mechanical failure, or there's black box data that's needed, and again the facts become a little bit more convoluted during discovery or during the investigative stage. Maybe possibly if there's comparative negligence, or if there's some issues regarding excessive speeding, then that can lead you to needing an expert. Okay, and so obviously it's important to establish your rapport with your experts beforehand. It's easier to have your experts on hand versus creating them and getting them at the time of your actual loss. So just have, if you can, have a reliable network of experts. Excuse me, and we'll go ahead and do the a summary and the takeaways. Thank you. Excuse me. So remember, experts are critical in complex subrogation claims, but not every claim requires an expert. As we said maybe about 5 or 6 times now, early retention preserves evidence and recovery potential. So if you can get your expert early on, then that's better. Excuse me, even before the claim is paid. Excuse me, origin and cause are not the same issue. So when you have a expert report, as Mike alluded to, from or maybe just a fire investigative report, it may tell you where the fire originated from, but it will not give you causation. So you have to look at those to make sure you have both, because they will identify specifically both cause and origin. Downward standards impact admissibility. Reliability and methodology matter, and you should use a cost benefit analysis when you're making your decision. Weak experts can destroy a strong case, and effective communication with your experts improve outcomes. The goal is not simply to hire an expert, check the box. No, the goal is to retain the right expert at the right time using reliable methods that will withstand challenges. And now I'm going to defer it over to Mike, and thank you all for sitting here through our presentation. Mike, you take it away.
Yep, that's exactly right. If it's a high dollar case or it's complex subrogation, you're going to need an expert, and you got to get the right expert, because I've actually changed experts. You get halfway through a case and you're like, this isn't working out, and you just sort of you bury your expert that you intended to use, and you have to go with plan B. But anyway, we do encourage you guys to ask questions. We'll get back with you. For everyone who registered, we're very grateful, and we thank you for attending this episode of the Subro Scoop. If you submitted a question, we didn't answer it, which we didn't because we ran short on time, we'll definitely follow up with you. Be sure to follow us on social media for more information and webinar updates. We're on LinkedIn, Facebook, X, and TikTok. Just search Weltman in the search bar to find our pages. Make sure to keep an eye out for upcoming webinars in your email inbox and on social media. We hope to see you there. You can reach out to either Tiffani or I at any time. We'd love to hear from you. And our contact information is going to pop up. There it is. So we look forward to hearing from you and seeing you next time. And if there's anything we missed or that you'd like to know, just let us know. Thank you very much.
Thank you all.